Hello and welcome along to our GDPR for HR webinar. My name is Rachel Lamsley and I'm a Senior Employment Law Advisor here at Ellis Whittam. So before we get started, a few bits of housekeeping. To listen to today's webinar, please use your computer speakers. There's no number to dial in on. If you have any questions, then to pop them in the questions section and we'll be able to come back to you after the event. And there is also a recording available on my EW for any EW clients that will be available after the event also. If you're having trouble accessing the webinar today, then let me know in the questions box and I'll be able to come back to you after the event. So, for those who are unfamiliar with Ellis Whittam, we provide high quality, fixed fee employment law and health and safety advice. We employ qualified solicitors and health and safety advisors who develop one-to-one relationships with our clients as we provide you with a named advisor to help you along your HR and health and safety journey. We don't just advise, we provide hands-on support and have a range of additional services that employers can take advantage of. We're currently supporting more than 10,000 UK employers from startups to national brands, and we really are experts in our field. We also have excellent client satisfaction rates, something we're really proud of here at EW. So what are we going to take a look at today? Well, the purposes of the webinar today is to answer some frequently asked questions in respect of HR and the GDPR. Now, the GDPR is not limited to HR, and it has far-reaching implications affecting many other areas of your organisation. If you have questions about the GDPR and its application generally, do get in touch with the Information Commissioner's Office or check out their website for more information. Today, we're going to be taking a look at 20 questions that we've split up into a few areas. Key points relating to the GDPR, principal protections, rights of individuals, accountability and data protection officers, impact on HR, breach of the GDPR, data protection bill, and what you should do now. Now, we've got so much to talk through and I'm certainly hoping to get finished by 11:30, but I apologise in advance if I run over slightly. So let's get started with the basics. What is the GDPR? Well, the General Data Protection Regulation, known as the GDPR, will replace our current data protection legislation. It's taken some 4 years to come to fruition, and its introduction marks a significant overhaul to the way in which we view data protection. So, who does the GDPR apply to? Well, it applies to all member states, and specifically to controllers and to processors. The ICO confirms that the definitions are broadly the same as under the Data Protection Act, i.e. the controller says how and why personal data is processed and the processor acts on the controller's behalf. If you're currently subject to the DPA, it's likely you'll also be subject to the GDPR. If you're a processor, the GDPR places special and specific legal obligations on you. For example, you're required to maintain records of personal data and processing activities. You will have significantly more legal liability under the GDPR if you're responsible for a breach. And these obligations for processors are new under the GDPR. So when does it come into force? Well, despite the overwhelming publicity around this area, the legislation won't actually come into force until the 25th of May 2018. And so you do have some time to prepare. What is key, though, is that you take this time to get ready and to prepare so that once the 25th of May comes round, you can hit the ground running. A big question that we get asked quite a lot is, well, as a result of Brexit, will the UK have to follow the provisions of the GDPR? The simple answer is yes. The UK will still be a part of the EU on the 25th of May 2018, and so these rules will apply to the UK. Matt Hancock, Minister of State for Digital, stated that until exit negotiations are concluded, the UK remains a full member of the EU and all the rights and obligations of EU membership remain in force. During this period, government will continue to negotiate, implement and apply EU legislation as it always has done. The outcome of the exit negotiations, however, will determine what arrangements apply in relation to EU legislation in future once the UK has left. So, for now, there's no way out of the GDPR. So what information does the GDPR apply to? Well, ICO guidance states like the DPA, the GDPR will apply to personal and sensitive personal data. The GDPR goes further than the DPA though and sets out a clear and more detailed definition, so it's certainly worth taking a look. In respect of personal data, the GDPR's definition is more detailed and it makes clear that information such as an online identifier, for example an IP address, can be personal data. The more expansive definition provides for a wide range of personal identifiers to continue and to constitute personal data, reflecting changes in technology and the way organizations collect information about people. For most organizations keeping HR records, customer lists or contact details, the change to the definition should make little practical difference. You can assume that if you hold information that falls within the scope of the DPA, it will also fall within the scope of the GDPR. Now, the GDPR applies to both automated personal data and to manual filing systems where personal data is accessible according to the specific criteria. This is wider than the DPA's definition and could include chronologically ordered sets of manual records containing personal data. In respect of sensitive personal data, the ICO says that the GDPR refers to sensitive personal data as special categories of personal data. These categories are broadly the same as those in the DPA, but there are some minor changes. For example, the special categories specifically include genetic data and biometric data, where processed to uniquely identify an individual. Personal data relating to criminal convictions and offences aren't included, but similar extra safeguards apply to its processing. So what are the principles referred to under the GDPR? Well, Article 5 states that personal data shall be processed lawfully, fairly, and in a transparent manner in relation to individuals. Personal data shall be collected for specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. It'll be processed in a way that's adequate, relevant and limited to what is necessary in relation to the purposes for what they are processed. It's accurate and, where necessary, kept up to date. Every step must be taken to ensure that personal data is accurate. If it isn't, you've got to have regard to the purposes for which it was processed and whether or not it needs to be erased or rectified without delay. It should also be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data is processed. This is unless it relates to data for public interest, scientific, historical, or statistical reasons when other provisions apply. It should also be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage using appropriate technical or organizational measures. Article 5 also requires that the controller shall be responsible for and be able to demonstrate compliance with these principles. So how can you process data under the GDPR? Well, the ICO states that the processing of data to be lawful under the GDPR, you need to identify a lawful basis before you can process the personal data. Under the DPA, these are known as the conditions for processing. It'll therefore be important for employers to review this aspect to ensure that you're processing data lawfully. Under the GDPR, the lawful bases include consent, processing that is necessary for the performance of a contract with a data subject or to take steps to enter into a contract, processing that is necessary for compliance with a legal obligation, processing that is necessary to protect the vital interests of a data subject or another person, processing that is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller, and finally, processing that is necessary for the purposes of legitimate interests pursued by the controller or a third party, except where such interests are overridden by the interests, rights or freedoms of the data subject. Now, consent has hit the headlines, and it seems that the other bases are often forgotten. Elizabeth Denham, the Information Commissioner, has released a blog in this matter and confirmed that consent is not the silver bullet for the GDPR. Just a note on this, if you haven't already, it would certainly be worth checking out Miss Denham's blogs. They're very informative and written in plain English, something that's obviously quite important when it comes to unpicking the GDPR. So, what has the Commissioner said in respect of consent? Consent under the current data protection law has always required a clear affirmative action. The GDPR clarifies that pre-ticked opt-in boxes are not indications of valid consent. The GDPR is also explicit that you've got to make it easy for people to exercise their right to withdraw consent. The requirement for clear and plain language when explaining consent is now strongly emphasised. You've got to make sure the consent you've already got meets the standards of the GDPR, and if not, you'll have to refresh it. Some timely guidance and certainly helpful words from the Commissioner, and really the point is made that emphasis has wrongly been placed on consent. We need to be clear. Consent is only one way you can lawfully process data. Don't forget about the other 5 bases that you can rely on. Identify which one from the start and you should be fine. Now, the ICO will require you to document your decisions to be able to demonstrate which lawful basis you use. The Commissioner went on to state that data protection impact assessments will be able to help you with the task of understanding how you can meet the conditions for processing and make your business more accountable under the GDPR. So, what are the specific rights of data subjects? Well, I thought it'd be helpful to give you a brief overview of those rights here. The first one, the right to be informed. This is much the same as under the DPA, although there is emphasis on the need for transparency over how personal data is used. This would usually be done in a privacy notice. There's the right of access, which we'll talk through shortly. There's also the right of rectification, which is essentially the right to correct inaccurate data. Any request for information to be rectified must be dealt with within 1 month of the request, and this can be extended by up to 2 months if the request is complex. If information has been passed to third parties, they must also be informed of the rectification as soon as possible. There's also the right to erasure, which is essentially the right to be forgotten. This is not an absolute right and will only apply in certain circumstances, but it does reflect the current position in the DPA, although the requirement for the individual to show that they have suffered unwarranted and substantial distress has been removed. Enhanced protection is provided to children, especially when involving social networking sites. It's worth noting there that the Data Protection Bill, which we will discuss shortly, proposes to extend that slightly. So we'll have to see what the detail of this legislation is at that point. The rights do continue. There is the right to restrict processing of data. This is similar to the current position under the DPA in that the individual has the right to block or suppress processing of personal data. If this happens, you're permitted to store the data but not further process it. There's the right to data portability. Where data is processed by automated means, individuals will be entitled to reuse that information for their own purposes across different platforms. For example, this will be particularly relevant for price comparison websites where information can be moved from one site to another. Any request from an individual must be dealt with within 1 month and again can be extended by 2 months if the request is complex. Information must be provided in a structured, commonly used and machine-readable form. There's also the right to object to the processing of data. Individuals can object to the processing of information. However, the extent of that right depends on the processing purpose. If the data is processed for the performance of a legal task or the organization's legitimate interest, then there are some exemptions available. If the data is processed for direct marketing purposes, then processing must stop upon a request being made. If data is processed for research purposes, the individual must have grounds for objecting. Finally, there are rights relating to automated decision-making and profiling, which we'll talk about more in detail. So, what is the accountability principle? Well, the accountability principle requires organisations to demonstrate that the protection principles we discussed earlier have been complied with. This is perhaps the biggest change being implemented by the GDPR. This, and in some situations, must be done in a number of ways. Number one, implementing and maintaining data protection policies. maintaining relevant documents on processing activities. This is required for the processing of data for employers with more than 250 employees. For those with less than 250 employees, documents will need to be maintained for higher risk activities, for example, where there's a risk to the rights and freedoms of the individual and processing of special categories of data. There's appointing a Data Protection Officer or a DPO where appropriate, which again we'll talk about shortly. It's following the principles of data protection by design and default. The ICO states that this is an approach to projects that promotes privacy and data protection compliance from the start. Often, these are issues that are bolted on or an afterthought or ignored altogether. This is not currently a requirement under the DPA, but is said that this will help organisations comply with their obligations. The ICO actually goes on to encourage organisations to ensure that privacy and data protection are key considerations in the early stage of any project and then throughout its life cycle. For example, when building new IT systems for storing or accessing personal data, developing legislation, policy or strategies that have privacy implications, embarking on a data sharing initiative or using data for new purposes. Finally, you can use impact assessments where appropriate. These may be carried out when using new technologies and where the processing is likely to result in a high risk to individuals. The ICO's guidance and code of practice is very useful and certainly worth checking out in respect of that. So, what is a DPO and do we need one? A DPO is a Data Protection Officer, and under the GDPR, the ICO states that you must appoint a DPO if you're a public authority, except for courts acting in their judicial capacity. If you carry out large-scale systematic monitoring of individuals, for example, online behaviour tracking, or if you carry out large-scale processing of special categories of data or data relating to criminal convictions or offences. You may appoint a single data protection officer to act for a group of companies or for a group of public authorities, taking into account their structure and size. The ICO states that any organisation is actually able to appoint a DPO. Now, regardless of whether the GDPR obliges you to appoint a DPO, you must ensure that your organisation has sufficient staff and skills to discharge your obligations under the GDPR. So, what does the GDPR say about employer duties regarding the DPO? Well, the ICO states that you must ensure that the DPO reports the highest management level of your organisation, so for example, the board. The DPO operates independently and is not dismissed or penalised for performing their tasks, and that they have adequate resource provided to them to enable DPOs to meet their GDPR obligations. So how does all of this start to impact on HR? Well, the GDPR can affect HR in a number of ways, so let's take a look at some frequently asked questions relating to that. What information do we need to give to employees and job applicants? Well, under the GDPR, we are expected to give much more detailed information in respect of the processing of their personal data. Employers have traditionally included information in contracts or privacy notices, but the GDPR goes further with its obligations to provide information. Under the GDPR, the information that employers must provide includes the identity and contact details of the employer as the data controller, the data protection officer's contact details if your organisation has one, the purposes for which the data will be processed and legal basis for processing, including if relevant the legitimate interest relied on, the categories of personal data to be processed, the recipients of the data, any transfer of data outside of the EEA, the period of storage, and we're not quite there yet, just a few more, the rights of data subjects, including the right to access, rectify, right to erasure of data, the ability to withdraw consent, or to object to processing, and the right to lodge a complaint with a supervisory authority. We need to include the consequences for the data subject of failing to provide data necessary to enter into a contract. And finally, the existence of any automated decision-making and profiling and the consequences for that data subject. Extensive, isn't it? So when should that information be provided? Well, it should be provided at the point of data collection. And if there is a new reason for processing existing data, then the employer will need to let the employee know about that further processing. Now, what are the changes in respect of subject access? Well, whilst this is similar to the current DPA requirements, there are a couple of notable changes that we need to be mindful of. The current position is that an employee can make a subject access request, which the employer needs to respond to within 40 calendar days. You could also, and still can, charge the employee £10 for that. The GDPR, however, will reduce the time an employer has to respond to the inquiries from 40 calendar days to without unreasonable delay, and in any case within 1 month. This can be extended by 2 months where the request is complex and numerous. However, how will that affect your business? Are you equipped to deal with the request in a short time frame? Also, the £10 fee that we've become accustomed to charging will also be abolished. A charge can be levied if a request for information is manifestly unfounded or excessive, but the charge would be limited to the administrative costs incurred. Get ready for the changes by making sure that your policies reflect what changes are going to happen in respect of subject access. Also start to think about a better way of actually retrieving the data should a request come in, as a month really isn't that long at all. The GDPR also states that where the data subject makes a request by electronic means, the information shall be provided by electronic means where possible, unless they request the data otherwise. Now, what is automated decision making and how does this affect following the GDPR? Well, automated decision making is where a decision is made without human intervention. Individuals have the right not to be subject to a decision when it's based on automated processing and it produces a legal effect or a similarly significant effect on the individual. Employers must ensure that individuals are able to obtain human intervention, express their point of view, and obtain an explanation of the decision and challenge it. So, could this affect your Bradford factor scoring process, for example, if that's automated? And does it make a decision? The ICO recommends that you should identify whether any of your processing operations constitute automated decision making and consider whether you need to update your procedures to deal with the requirements of the GDPR. Now, how will the GDPR affect the retention of documents? I think we can talk about this in 3 ways. The retention of data relating to an employee, an ex-employee, and separately recruitment data. Taking a look firstly at ex-employees, the position doesn't change a great deal in that we should not be keeping the data for any longer than is necessary. What the GDPR does require, however, is that employers are more transparent about their retention policy. Now, what about recruitment documents or employee documents? I've already discussed the information that we need to give to recruits and employees in a privacy notice, but there will be circumstances when employers need to retain information in case of a legal dispute or employment tribunal claim. For current employees, you may also need to retain certain information for HMRC or payroll purposes. In these circumstances, an employer should only retain information that is absolutely necessary until the relevant limitation period expires. If you retain a CV for potential future roles, will you need their specific consent? And the answer is probably yes. Your policy should state what happens to unsolicited CVs as well. Do you keep them or not? And have you let the candidate know your policy in respect of that? Now, something that's obviously been widely publicised is in respect of breaches of the GDPR. So what should organisations do if there is a breach of the GDPR? Well, the GDPR will introduce strict notification rules where a breach has occurred. A breach for the purposes is a breach of security leading to the destruction, loss, alteration, unauthorised disclosure of or access to personal data, where it's likely to result in risk to the rights and freedoms of individuals. You must also notify individuals directly where a breach is likely to result in high risks to the rights and freedoms of that individual. Any such breach must be reported to the relevant supervisory authority, and in the UK, that's the ICO, and that must be done within 72 hours of the breach. If the breach is likely to result in a high risk to individuals, data subjects must be informed without unreasonable delay. So, what are the fines? Another area that has attracted quite a lot of press. Well, let's take a look at what the fines are at the moment. The current position is that if there is a DPA breach, the fines are limited to £500,000. Under the GDPR, well, it's a slight understatement to say that this has only just been increased. The limits on fines are light years away from the £500,000 under the DPA. In fact, if an employer breaches its obligations under the GDPR, it may be subject to administrative fines of up to around £17 million or 4% of the undertaking's worldwide company turnover, whichever is higher. It's fair to say that this is part of the reason businesses are terrified of the changes. So what's the truth about fines, and what are the press not widely reporting on? Well, these fines are not mandatory, and they should not be imposed for minor infringements or where the fine would impose a disproportionate burden. The decision about the amount will be based on a number of factors, such as the nature and gravity of the breach, damage that the individual has suffered, and any mitigation. It also considers any previous infringements and whether this infringement was intentional, amongst other things. Back to Elizabeth Denham, the Information Commissioner, who we referred to earlier, she's also keen to dispel these myths. Yes, these are extraordinary fines and are available, but Elizabeth Denham emphasises that reality is that the GDPR's main aim is to put the consumer and the citizen first. Elizabeth Denham goes on to state that it's scaremongering to suggest that the ICO will be making early examples of organisations for minor infringements, or that the maximum fines will be the norm. Elizabeth Denham emphasised that issuing fines has always been and will continue to be a last resort. Just last year, the years 2016-17, the ICO concluded 17,300 cases, and out of those, only 16 of them resulted in fines for the organisations concerned. Elizabeth Denham states that predictions of massive fines under the GDPR that simply scale up penalties we've issued under the DPA are nonsense. Now, Elizabeth says, don't get me wrong, the UK fought for increased powers when the GDPR was being drawn up. Heavy fines for serious breaches reflect just how important personal data is in the 21st century world. But the ICO intend to use those powers proportionately. The ICO confirmed that while the fines may be a sledgehammer in their toolbox, they have access to lots of other tools that are well suited to the task at hand and just as effective. They go on and confirm that, like the DPA, the GDPR gives us a suite of sanctions to help organisations comply, so warnings, reprimands, corrective orders. And whilst they won't hit organisations in the pocket, their reputations will suffer a significant blow. Another great blog by the Commissioner, and I'd recommend that you keep up to date with her. Elizabeth Denham's comments are very important. The ICO are clear about their remit and that this is not just about hitting businesses in the pocket simply to make an example of them. It's about so much more than that. So what about the rest of the requirements under the GDPR? Well, as confirmed at the start, the GDPR is far-reaching and therefore has an impact across any organisation. It's not limited to HR, and so you need to make sure that you're complying with your wider obligations under the GDPR. Now, what is the Data Protection Bill? Well, the bill will bring the GDPR into UK law. Whilst the GDPR is immediately enforceable in the UK on the 25th of May 2018, there are certain areas that the UK can have some discretion over. The UK can set out in the bill how they want to exercise those discretions. And also, by bringing the EU law into our own law, we'll make sure that we are able to better prepare for the UK's future after we leave the EU. It is worth noting at this point that the UK haven't actually stated exactly how they intend to exercise those discretions, and so that remains to be seen. Mr. Hancock, the Minister of State for Digital, released a statement of intent on the 7th of August 2017 and confirmed that the purpose of this bill is to bring our data protection laws up to date. He stated, "Our measures are designed to support businesses in their use of data. The new data protection bill will give us one of the most robust yet dynamic sets of data laws in the world. The bill will give people more control over their data, require more consent for its use, and prepare Britain for Brexit." Now, the GDPR has allowed for considerable scope for the UK to derogate and deviate from the regulation, as this is why we're looking to introduce the bill. We understand that new criminal offences will be introduced not covered by the GDPR, including intentionally or recklessly re-identifying individuals from anonymised data or knowingly processing such data, and an offence of altering records with the intent to prevent disclosure following a request from an individual for that data. Again, there's limited detail on this, and so exactly how it will play out remains to be seen. So, what should you do now? Well, firstly, don't panic. Just make sure that you're taking steps to comply with all aspects of the GDPR, not simply from a HR perspective. We think the key thing to take away from a HR perspective is that whilst it's important to start to plan for the GDPR, we also need to wait and see what the content of the bill will be. It looks like it will align quite closely with the GDPR, but the devil is always in the detail regarding the way in which the UK chooses to exercise its rights to implement the regulation. EW will work with you to ensure that your employment policies, procedures and contracts accurately reflect the requirements under the GDPR and Data Protection Bill once this is released. But something to get you on your way, we have prepared a checklist which will be available after the event, which should help you start to think about steps you need to take to get ready. So before I sign off, I just wanted to let you know that we've released our dates for our October free seminars. Our seminars will run up and down the country, and so why not join us to discuss how to avoid tribunal fees and unravel the complexities of key health and safety legislation. I've popped the link in the chat, so do get registered for your free place. That brings us to the end of our webinar today. Thank you so much for joining me. At EW, our employment law advisors and health and safety consultants are on hand to help you understand your legal obligations and make any process easier and smoother. And so if you've got any questions about today or our services generally, then do get in touch. Our contact details are right there for you, and they will be in our follow-up email after the event. I hope you have a great day.